Good evening. My name is Joshua Houston. I'm General Counsel representing Texas Impact, and we are here respectfully against the committee substitute, House Bill 3698. We received the committee substitute yesterday, and we greatly appreciate the representative in her office for that. We appreciate that people of faith are no longer singled out for special treatment in this bill. We appreciate that the provisions affecting the confidentiality of the pastor-parishioner relationship have also been removed, but we still have concerns. The fundamental question of this bill is how intrusive do we want the state to be in the affairs of religious organizations? And when you add criminal penalties, that adds an element of fear on top of that. Though we do not think it's the author's intent, many of our denominations' internal governance structures appear to be implicated. The definition in the committee substitute is so broad, we are unable to discern to whom all this applies. It could easily include not just faith, but other nonprofits, civic organizations, and homeowners associations that routinely employ forms of ADR. It's unclear exactly how low the threshold is on what is already often a very informal proceeding. What is particularly concerning is that criminal penalty that's involved. With regard to faith and some examples of facts that might apply to such a law, at the local level, so a local church, not a denomination, but a local church, there's often mediations that occur between a pastor and the local congregation, such as if there's a dispute in an employee handbook, it often says go to mediation. Within the local congregation, you can have people within the factions in the congregation fighting, and that often becomes mediated by the pastor. Families often come and ask that pastor to mediate their familial disputes. And often congregations will mediate in the community, for example, with victim offender mediation services. That's an example of a way that a local congregation can be engaging in the community. At the denominational level, there are different kinds of judicial councils that mediate disputes. Often it's between one pastor and another pastor within the denomination. Sometimes it's between a congregation and another congregation within the denomination. You often have decisions over who owns the property, which gets into issues of who is the true church, which is best done at the judicial council level of an ecclesial body. In employment law matters, there's been, unfortunately, many clergy trials that have made the news lately that would possibly be implicated by this bill. And many faith communities have a theological predisposition to resolve disputes through encouraging mediation rather than contentious litigation. So, for instance, we have national denominational level dispute resolution centers. For instance, if you're curious what one of these things we're talking about might be, the United Methodist Church has a ministry called Just Peace. It's JUSTPEACE, UMC.org, if you're curious and want to look that up later. Given all the ways the faith community is directly affected by this legislation, we think that if this legislation is to move forward, that there needs to be a broad stakeholder process. We've been in conversation with our member denominations, and they have asked us to tell you that they would like to send their own attorneys and their own experts if there is to be a stakeholder process. And if there are problems with the faith community not following Texas law, then I would hope that that would be brought before a court of law. That seems the more appropriate branch of government rather than jumping straight to legislative policy making. I thank you for your time this evening, and we look forward to working with you.
Any questions from witness members?
Thank you.
We have Ken